Go ahead, sir.
David I. Goldstein, appearing on behalf of the defendant.
This case opens quietly, but what unfolds is anything but simple. You're about to watch a defendant walking a legal tightrope, tethered literally and legally, while the court tries to decide whether his explanations are bad luck or bad faith. At the center of it all is Judge Simpson, a judge known for zero tolerance when it comes to bond conditions and domestic violence cases. On one side, the defense is asking for patience, flexibility, and benefit of the doubt. On the other, the prosecution is warning the court that this defendant may already be testing how far he can push the system. And here's what makes this case dangerous. Electronic monitoring, exclusion zones, civil standbys, tampering allegations, and timelines that don't line up cleanly. One mistake alone might be forgivable. But when mistakes start stacking up, cut straps, late-night movements, and disputed phone calls, the courtroom stops talking about misunderstandings and starts talking about risk. You'll hear arguments about comfort, about pants, about a knife, and about a strap that was damaged but not cut. You'll also hear why that distinction may not matter at all in the eyes of the court. And later, we'll see how other defendants in the same courtroom fare when they try to explain missed tests, relapses, unpaid retainers, and broken bond conditions.
All right. What are we doing on this case?
Going to be setting it for an exam, Your Honor.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available on the 23rd.
Your Honor, I'm going to be out of the country on the, out of the state on the 23rd. I'm available the 30th or the first week in August, either one.
People have their witnesses available on the 30th?
July.
Yes.
He does the bond violation.
Ms. Randall. I do see it.
Which judge is that on the 30th, Your Honor? Do you know?
I'll get to that in a minute.
Okay. Your Honor, I am aware of the A bond violation. I did discuss it with the Tether agent. When the court's ready.
Okay, go ahead.
Okay. Your Honor, I'm aware that there was a violation, alleged violation, that he was in the exclusion zone. In that situation, Your Honor, my client contacted me, said he wanted to get some property from the location where he was excluded. I told him he could do a civil standby. Civil standby. He did contact the police. He went to a location, waiting for the police to arrive. And before the police arrived, the Tether people apparently violated him.
Well, there's that issue, but then I also have that his tether strap was cut.
It wasn't cut, Your Honor. It was damaged. He had the tether on when the agents arrived, and it was replaced, and he still has it on.
But it was split from the bottom. Why was that?
He was doing something with his pants, Your Honor, and may have accidentally done it, but it was not intentional. In fact, and as I said, he was on when they got there.
I get that, but what could he have been doing with his pants that caused the tether strap to split?
I was trying to cut a hole around it for more comfort on my ankle, and I accidentally
cut a hole around what?
My pants. Cut a hole in my pants.
This is one of those courtroom moments where credibility lives or dies in seconds. The defendant is asking the court to believe that a knife, a pair of pants, and a court-ordered monitoring device accidentally collided in just the wrong way. Legally speaking, intent matters, but outcomes matter more. Courts don't require someone to mean to tamper with a tether. They only need proof that the device was damaged while under the defendant's control. And from a judge's perspective, this story raises uncomfortable questions. Why use a knife near a monitoring strap at all? Why not call the monitoring company? Why not request an adjustment? Why modify clothing around a device specifically designed not to be modified? This is also where courtroom psychology kicks in. Judges listen not only to words, but to how explanations are structured. Rambling, repeated justifications, or overly detailed physical stories often signal panic rather than clarity.
So I can get more comfort.
He was trying to cut around the tether.
Trying to cut around it, but now I just put my pants through it instead of going over it. And I accidentally cut the tether on accident when I was cutting a hole in my pants, trying to cut around it. This part. It wasn't like I was trying to cut it off or nothing. It wasn't that.
You were trying to cut a hole around the tether and you
More comfort.
cut the strap.
Just
Well,
a-
it didn't,
it
well,
was-
Your Honor, you say
No,
cut. There was damage to the strap, but it wasn't cut off.
Okay, if you want to play word games, I'll play word games. I'm looking at the report. It was split from the bottom, so it was cut.
Yes.
It wasn't cut off. I get it, or it didn't come off of his leg. I'm just trying to figure out how you cut the strap when trying to cut a hole in your pants.
I didn't do deep. Now I'm holding my pants over it. It went too deep. I was cut all around it. And
You're cutting with a knife?
I used a knife to cut a hole in my pants. I wasn't trying to cut it off though. That was not my intention.
Any response from the people?
Well, I mean, I'm obviously concerned, and then he went past the victim's residence twice. I just saying it's because he wanted to get a civil standby, but he should work that out first and contact the tether agency before he did that. I mean, this is a domestic violence case. He had requested a $50,000 bond to begin with.
This single sentence changes the weight of everything you've heard so far. Domestic violence cases operate under a completely different risk lens. Courts assume heightened danger to alleged victims, higher emotional volatility, and greater risk of retaliation or intimidation. That's why prosecutors initially pushed for a $50,000 bond, not because of paperwork, but because of potential harm. So when the judge hears tether damaged plus exclusion zone entered in a domestic violence case, it's not treated as technical non-compliance. It's treated as a safety threat. The prosecution is building a pattern. First tampering, then location violations, then proximity to the victim's residence, twice. That sequence matters legally. Patterns suggest intent, and intent justifies harsher restrictions or full revocation of bond. To the court, this is no longer about whether the defendant wanted his ankle to be comfortable. It's about whether the victim can safely sleep at night.
We were denied that at the original arraignment. So there's concerns with the tampering of the tether and also its whereabouts.
Well, is there an indication that the civil standby was called for?
Yes.
And I don't have any of the information.
We can get that from the police department, Your Honor.
Probably if I can.
Which one?
Yes.
Who did he call?
Uh,
The sheriff's department?
Sheriff's Department. And it was Ann Arbor though.
Pardon?
It was Ann Arbor. I called Ann Arbor.
Which department did you call?
The sheriff's. The non-emergency line.
Okay, the Ann Arbor Police and the Sheriff's Department are two different agencies.
It was the police though.
The Ann Arbor Police?
Yes.
So you called the Ann Arbor Police Department? Got a civil
before I
standby.
left. Before I came out here, I did all that.
What?
Yes, before I left out from my house, I did call. I made that call before I left. And they told me to just give them a call when I get to Ann Arbor.
It comes from Flint, Your Honor.
Yes, I don't stay out there.
And did you call them?
Yes.
What date?
Whatever the
Thank-
date, whatever the date of the violation is, Your Honor. It all happened in one day.
So the tether cut was on the 28th at 1:34 a.m. Then the next day on the 29th at 7:30, they received a call that the defendant was in the exclusion zone, the monitoring center. The defendant drove through the exclusion zone, passing the victim's residence twice. Once the defendant became stationary, they contacted Washington County Metro Dispatch and they arrested him.
Twice, not once. That detail alone can end a bond hearing. Courts understand that GPS systems aren't perfect, but repeated proximity to a protected address is almost impossible to dismiss as coincidence. One pass could be a wrong turn. Two passes start to look intentional. And when it's combined with a damaged tether from the day before, the timing becomes explosive. Legally, exclusion zones are absolute. There's no almost. There's no I didn't stop long. Being detected inside the zone is enough. It triggers automatic reporting, risk assessments, and in many jurisdictions, immediate arrest protocols. The defense tries to pivot to the civil standby argument that he was attempting to retrieve property legally with police present. But without proof, the court can't rely on that story. Judges don't operate on intentions. They operate on documentation. Viewer question: if you were the judge here, would you treat this as a misunderstanding or as the start of deliberate boundary testing?
Now, Your Honor, I realize there's an
Hold it.
exclusion.
No, hold it. I get that. But if he's got a civil standby and he's telling me he called the county, the moment Metro Dispatch is called, they're going to know that he's there. I need proof that there was a call for a civil standby, because my problem right now is I've got what appears to be a tether tamper on the 28th, and then I have him in the zone on the 29th.
With the tether on, Your Honor.
Yes.
Okay, I'm still not understanding this whole knife thing, but he's in the exclusion zone and I don't have proof of a civil standby, because that usually will appear very quickly. There would not be a violation filed.
Your Honor,
So I'll tell you what, I'll pass the matter. Somebody needs to get, you guys need to get over to the sheriff's department, get that information on the civil standby, and I'll call it back up. But if I don't have proof of the civil standby, then we're going to have a problem.
This is Judge Simpson drawing a line in permanent ink. A civil standby is not a casual favor. It's a recorded police action with dispatch logs, officer names, timestamps, and location data. If it exists, it can be verified within minutes. The fact that none of that is immediately available deeply undermines the defense narrative. And notice the structure of the judge's logic. Tether tamper on the 28th, zone violation on the 29th. That's escalation. Courts treat escalation as predictive behavior, a sign that restrictions are failing. By passing the matter temporarily, the judge is being procedural, not lenient. He's giving the defense one final opportunity to prove legality. Without proof, bond survival becomes mathematically unlikely. This is how judicial patience looks. Calm voice, slow pace, but consequences quietly loading in the background.
all right, thank you.
Court calls the case, People versus Noah Wood. Yeah, his light's on.
Yeah, I know you know, this, you know, I'm just, okay, hang on. There we go.
How many people does it take to turn off a light on the phone?
Okay,
3.
thanks, man.
Okay.
David I. Goldstein, appearing on behalf of the defendant. All right. Your Honor, in the interim, my client showed me on his phone log, confirming that on the June 29th at 2:20 p.m., he did make a call to the Ann Arbor Police Department. He called them this morning. They gave him oral confirmation that the call was received. He has now put in a FOIA request. They won't give him a written confirmation without a FOIA request, and he did file the FOIA request this morning. But I can show the court on his phone where the call, in the call log, where that call was made.
Okay. You're wanting to set for exam?
Yes, Your Honor.
All right. Here's what I'm going to do. I will set it for a preliminary exam. With regard to the bond violations, I'll let the court handle any potential bond violations. He's got a new thing on the tether, right?
Yes, Your Honor.
Did you get all of your property or whatever you were looking for that date? So there's no reason whatsoever for you to be back in that area?
No.
This question is surgical. The judge eliminates future excuses in one sentence. Once the defendant confirms he retrieved his property, the legal justification for being anywhere near the exclusion zone evaporates completely. No pending reason, no logistical necessity, no gray area. From this moment forward, any future proximity becomes intentional by definition. This is how courts protect victims long-term, not just by punishing violations, but by stripping away excuses before they can be reused.
Preliminary examination will be set 30th, 2024, 9 a.m. before
Fresh hour.
Judge Fresh Hour.
Thank you, Your Honor.
This time bond will continue. People versus John St. Germain.
Counsel Overwater, Assistant Public Defender on behalf of Mr. St. Germain.
Your name, sir?
John St. Germain.
Thank you.
Your Honor, it's a date and time set for a probable cause conference. We are still trying to get discovery on these matters. The video for one of the two cases was sent to my office yesterday. The other one we still do not have. As a result of this, we still cannot set we cannot set one of the cases for preliminary examination. The other one still has not been set for preliminary examination. In both cases, my client's been in custody for 28 days. So we're past the 21 days for the preliminary examination. My client has directed me to move for a dismissal on the basis of that 21-day violation.
Okay, I'll tell you what. That's fine. Then I'll grant that, but I won't grant it until later. Well, I'll hear the motion later and allow the people to prepare paperwork so that we can just do all of it, swear it out, and arraign him on that all today. And then all the time that he's been in, he would lose any credit. So that's what we'll do. That would be my remedy.
That doesn't sound good.
No, it doesn't. But that's what happens. That's how I work.
This exchange reveals how brutally procedural the system can be. The defense moves for dismissal because the prosecution missed the 21-day preliminary exam window. On paper, that's valid, but Judge Simpson offers a legal workaround. Dismiss now, refile today, arraign again, and erase all custody credit. It's lawful, it's efficient, and for the defendant, it's devastating. This is the hidden reality of criminal procedure. Technical victories don't always equal real wins. Sometimes exercising your rights strategically can leave you worse off than staying quiet. It's also a reminder that judges control the tempo of justice. Delays, resets, and procedural remedies can feel abstract, but they translate directly into days, weeks, or months behind bars. Viewer question: would you push for dismissal here and risk losing your time credit? Or accept delay and stay in custody hoping for leverage later?
What can I do?
I've told you we can adjourn to get the video and then set the cases for preliminary examination.
Sure. Okay.
Then thank you, Your Honor. I would withdraw that motion and I would ask for a brief adjournment of the probable cause conference to get the remaining video.
Do you think you'd be able to have those in a week, or did you need two? I appreciate.
Northfield Township Records Department reports that they sent the link yesterday. And so Mr. Runick is working on
Getting that. Got it.
Mr. Overwater feels confident with a week. I'm happy to put it a week if you need 2 weeks.
I'm fine with a week if
All right.
Mr. Ganache thinks we'll have it.
Probable cause conference, July 18, 2024, 9 a.m. Well, continue.
Thank you, Your Honor.
Your Honor, can I address the court?
Sure.
I'm wondering about getting my bond reduced so that I could post it, because right now it's a little bit high for what I can afford.
Well, okay. Have you talked to your attorney about that?
Yeah, I mentioned it.
We did, Your Honor, and we made a bond motion at the last hearing.
I know.
So the only thing that's changed is the matter continues to be delayed on the issue of discovery while my client is still incarcerated as a result.
Right. And he violated the conditions that we released him on the last time.
I did, and it wasn't on purpose. And I meant no disrespect by it. That's not something that would happen again. As my situation has changed and I have transportation now to my court dates, I have a healthy spot to live in with,
And the court recalls this was explained to the court a few weeks ago, but he does have stable residence with friends, one of whom is a licensed social worker and would look after him as well as ensure his appearance in court.
Had to issue a warrant on one. There was a bond violation. I'm not going to change the bond at this time. I mean, I'll see him next week and we'll see exactly where we are, but I'm not changing. Motion for bond reductions tonight.
Thank you, Your Honor.
This is the sound of credibility collapsing. The defendant tries to humanize himself. Transportation issues fixed, stable housing, social worker supervision, apologies. But the judge weighs one fact heavier than all of that: prior bond violation. In courtroom logic, compliance history outweighs future promises. Judges aren't paid to believe intentions. They're paid to manage risk. Once a defendant violates conditions after already being granted release, the court mentally reclassifies them, not as low-risk struggling person, but as unreliable variable. And that classification follows them into every future hearing. From this point on, every request this defendant makes for leniency, schedule changes, or modification will be viewed through the lens of "you already broke the deal."
Thank you.
Versus Devin Schiller.
Nimish Ganatra for the people.
Kenneth Overwater, Assistant Public Defender, on behalf of Mr. Schiller, who approaches and stands to my right. Mr. Schiller, would you state your name for the record?
Devin Matthew Schiller.
Okay, what are we doing?
Your Honor, I'd be asking to adjourn the probable cause conference. There is a bond violation that I assume the court has seen.
Yes.
So I did speak with my client regarding that. I did indicate to me that he did have a relapse a few weeks ago. He has begun going to, is it Narcotics Anonymous, NA meetings?
They're technically A, but it's kind of like a mixed group.
Right. So he's going to meetings. He's been to, I think, 7 meetings in the last about 10 days. He did provide me with some sign-in sheets to verify some of the later meetings. Additionally, it looks like Community Corrections has referred him to outpatient. He has an intake for that on July 15th, which he will be attending. He continues to test, knowing that those levels are going to reduce, but they will eventually be testing.
Well, I don't have levels. And I mean, I have 3 consecutive tests of fentanyl.
This is where science collides with hope. The defense is arguing addiction physics, that fentanyl can linger, that levels can decline slowly, that relapse doesn't mean ongoing use. The judge is arguing patterns. 3 consecutive positives. Not 1, not 2, 3. In bond supervision, the court doesn't need to prove addiction. It only needs to decide risk. Repeated positives suggest instability. Instability plus release equals danger, not just to the defendant, but to the public. Notice how the defense frames this as self-created treatment. That language is telling. Courts prefer structured programs with accountability, not self-designed recovery plans. Judges don't discount effort, but they distrust improvisation when lives are on the line. And the judge's tone shifts. It becomes firmer, narrower, less negotiable. Because from a judicial standpoint, continued positive tests aren't a setback. They're evidence that the bond conditions are failing. Viewer question: if someone keeps testing positive while claiming they've stopped, should the court trust the future or the data?
I read on.
When did you start this programming that you kind of created for yourself?
So he started attending the AANA meetings in late June after he had his relapse. He had thought that this was something he could manage kind of on his own. And then he has realized. We're going to have to
find something, Mr. Allen. We're going to have to find something else.
Judge, I'm going to ask the court to consider adjourning this and give him an opportunity to stay on the path that he's on. He has a referral for outpatient, which is not something that he was doing, and that was the recommendation of Community Corrections. If he's taken into custody today, that's going to derail the treatment plan that he has in place, and it's only going to delay
it to the extent it's a treatment plan. I mean, what it is it's his notion of what to do. But I've got 3 consecutive testing of.
Your Honor, may I say something?
I don't think that's a good idea.
Okay.
All right, Your Honor, he was at one point a high user. In that instance, it takes time for the levels to reduce. For the levels to reduce. We don't know what the levels actually are, but the report indicates that those can be sent out for testing to determine that the levels are in fact reducing.
If I look at this testing, I don't think he's ever stopped.
I have.
Because the first test, since this case anyway, because the first test, he is an unable or refuse. There's no test. And then 3 consecutive tests, he's testing positive for fentanyl.
And Judge, he reports the last time he used was in late June. Those numbers are reducing. If the court will allow him, there are going to be negative tests coming. He has an intake for outpatient treatment at community
Fentanyl
corrections.
won't stay in his system that long. That means he's continuing to use.
I promise you, it will be negative next week. When you're a chronic user, I read online that it can stay in your system for up to 4 weeks. I haven't been using in multiple weeks.
Somebody needs to come back with a plan for his release, but he's going in right now. You're not going to have three tests coming back.
The
like that.
levels are going.
You can argue with me if you want.
I'm not gonna
Bonds
argue with
revoked. Defendants remanded. I'll set it over to next week, the 18th, 9 a.m.
Thank you, Your Honor.
This is the courtroom equivalent of a trapdoor opening. Bond revocation isn't punishment, it's prevention. The court isn't saying you're guilty. It's saying we can't manage your risk outside custody. And this decision isn't emotional, it's mathematical. The judge weighs multiple positive tests, no verified levels, ongoing usage dispute, unstructured treatment, community corrections concerns that stack overwhelms optimism. For defendants struggling with addiction, this moment is devastating. They aren't being jailed for using. They're being jailed because the court believes release no longer protects anyone, including themselves. This is the brutal paradox of bond. Freedom depends on compliance. Struggle erodes trust, and once trust collapses, incarceration becomes protective custody in judicial terms.
So I don't have no that. I have no that.
That was a woman that just.
Who was that? Get security down here and find out who the heck that was, because they're not going to walk out of my courtroom that way. Who? Did you see who just came out of the courtroom, Joe?
I did not. I was in the conference room.
On a
Oh,
black.
it's a woman in a black t-shirt. If she was down in courtroom C, I want her brought back. Court's going to stand in recess.
Robert Ellman with and on behalf of Mr. Hornberger.
Your name, sir?
Thomas Warnberg.
Right.
Your Honor, today's date and time set for PCC. I would at this time like to set this matter for an exam.
I would set it for an exam, except that your client hasn't been tested.
I understand, Your Honor, and I am in receipt of the bond violation report.
Why hasn't he been testing, Mr. Allen?
Your Honor, he missed one test, the first test on the day that we had court due to his misunderstanding of what time court was. And after that, Your Honor, I don't have a good answer.
Well, just so that we're clear on the bond violation, on the June 12th, he did take a test, tested positive for cocaine, fentanyl, and THC. And then the next 3 successive tests, he missed.
And my understanding, Your Honor, is that he thought after missing one test that because that was a violation that he did not need to test further. I've advised him that that was a mistake. He wishes a further opportunity to test on this matter.
You wanted this set for a preliminary examination?
Yes, Your Honor.
Is all discovery complete?
Yes, Your Honor.
People have their witnesses available the 23rd?
Yes, Your Honor.
Preliminary examination in person, July 23rd, 2024. 9 a.m. That's before Judge Washington. You can't just decide you're going to test, not test, do whatever, and particularly have a dirty test and then miss all of the other tests. At this point, defendant's bond is revoked, defendant's remanded. Go with my bailiff, sir.
Another defendant. Same pattern, same outcome. Missed tests plus dirty tests equals loss of freedom. Courts don't accept "I misunderstood" when bond paperwork spells out obligations. Once you miss a test after a positive, the court sees evasion, not confusion. Judges view testing like oxygen masks. Constant, mandatory, non-negotiable. You don't choose when to breathe. What's striking here is how quickly the judge moves. No debate, no extended warning. The bond is revoked in one sentence. That's because bond isn't a right, it's a privilege. And privileges disappear when rules are ignored. This courtroom isn't punishing crime, it's policing trust.
Come see you soon, Mr. Hornberg. Have a good day, Your Honor.
You do the same. Court calls the case. People versus Kanasia Johnson Jackson.
Oh, you on behalf of the people.
Robert Mullen on behalf of the defendant.
Your name? Yeah.
Kanasia Johnson Jackson.
All right. And this is actually, I think, a time for a PCC and your motion to withdraw.
Yes, sir.
All right. Go ahead with your motion to withdraw.
Your Honor, I put most of the important facts that I think that are necessary. If the court wants details, I'm more than happy. But I believe based on the rules, if I have a financial hardship and continued representation, the court would take that as a reason for withdrawal. But more importantly, if I can withdraw at a time which will not create any kind of substantial hardship on behalf of the defendant, and I think that would be the case here. We do have all the discovery that we think we're entitled to at this time, but we have not had a preliminary exam. And I don't believe that any of my clients' rights have been prejudiced.
And Ms. Johnson Jackson, anything you want to say regarding Mr. Mullen's motion to withdraw?
Yes, I don't agree with it.
Pardon?
I don't agree with it.
Okay. What don't you agree with?
Based off the that was provided to me in reference to, can I see your paper?
Absolutely.
The one that's under here.
Oh.
It's in there, like, way down. The email that you sent me this morning.
You want the motion? You want the, didn't you read me something?
Yeah, that's what I'm talking about, the email that
Oh,
was.
hang on.
Thank you.
Mhm.
So this morning, the email that was sent, which is what I'm about to read, it says the defense counsel appear on behalf of the defendant with the understanding that defendant will be remitting forthwith to defendant counsel a retainer payment as agreed upon by defense counsel and defendant. The second one was defendant subsequently failed to remit said retainer payment, nor has defendant indicated when the retainer will be paid. 1 second. The third one is an attorney may withdraw if his client fails substantially to fulfill an obligation to the lawyer regarding the lawyer services and has given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. So in reference to all that, yeah, in reference to all that stated, the retainer, so him and I, it seems like there is confusion between him and I in reference to the retainer fee and just like the distance of my case. Does that make sense?
No.
So I don't agree. So what he's doing is a motion, right?
It's a motion to withdraw as your counsel.
Right. So I don't agree with the motion to withdraw in reference to this is my probable cause hearing, right?
This is a rare moment where money becomes destiny. Private defense depends on payment. When that collapses, representation collapses, and courts are forced to balance fairness against professional survival. The defendant isn't wrong emotionally. Losing your lawyer feels like abandonment, but the lawyer isn't wrong legally. Working unpaid in a capital-level case can destroy a practice. Judges see this conflict constantly, and they know one thing: a resentful, unpaid attorney is more dangerous to a defendant than a fresh public defender. So the court reframes the issue. Withdrawal isn't harm, it's protection. This is how justice adapts. When private systems fail, public systems absorb.
Well, it is a probable cause hearing, yes.
Right, so, okay, so I have a question. So with him withdrawing as my counsel, are we still doing this today or is that postponed?
If he withdraws, okay, ma'am. So I have to make a determination as to whether or not there are grounds to withdraw as
Understood.
I'm looking at it. So I asked, Mr. Mullen stated his position. I have the motion in front of me, and I'm asking what your position on this motion to withdraw is.
Oh, I absolutely disagree. And to my understanding, it seems like most of like videos and just maybe more statements have been given to my defense, but to my understanding, that is the discovery, but I don't know anything about it because him and I haven't spoke about it. Does that make sense?
Okay, it could, yes.
Okay.
So, ma'am, let me just ask you this. His basis of withdrawing is that you were supposed to, you had certain financial obligations. It's indicating that you haven't fulfilled those. I don't need to know what those specific terms are because it's not relevant to at least the court's determination at this point. Are you indicating to me that you did fulfill those obligations? And therefore, okay, but fully fulfill those obligations?
I haven't fully fulfilled obligations, but I have put money in his hand. So that's why, yes.
Okay.
General, may I respond or do you want me to just be quiet?
Go ahead.
Yeah, she's right. She's paid me some money, of course. But the reality of it is it's less than a third of what the retainer understanding was in agreement for this case. In addition to that, I haven't paid anything in almost 3 months. There's been no efforts to pay me. I've had multiple meetings. I had a meeting on the 26th of June specifically to make this a focus. I don't like talking about money. I'd rather work as a lawyer and do the work on the case and have those meetings. But as you know, it becomes a conflict of interest when you're not being paid. This is a capital case. She's entitled to substantial work on this case as it being a capital case. And when I'm not getting paid, I don't know how I'll be able to do it. This is not like an OWI where even if I'm not getting paid, I could probably suffer through it and it wouldn't damage my practice or my mental health. This would be maybe a little more of a different of a situation. But to say that she hasn't paid me any money.
I don't think that you said that.
I just want to make it clear. She has, but she has not even come.
That's not what I got from this. I get it. So, ma'am, are you telling me? I understand that you've paid part of what's there.
Yes.
Okay. But you haven't paid what the entire amount agreed upon was.
You said what the entire amount?
What the entire amount. You haven't paid that.
I haven't paid the entire amount.
Okay. So are you telling me that you're going to?
What I'm saying is there has been some confusion in reference to the amounts. There has been efforts, multiple efforts to make payment, and I have made payment. I have not made the entire amount. But
so let me just ask you this. As to the entire amount that was requested to obtain of the retention, why hasn't the full amount been paid?
Because there was confusion on the full amount.
Your Honor,
I don't know what that means.
Miss Johnson Jackson wrote me out a payment schedule. This was her schedule. It wasn't my proposed schedule. Yeah. She wrote me out a payment schedule and provided it to me and has not even lived up to that. And like I said, less than a third of the retainer in the case. And just so this court knows why I'm a little nervous on top of it is, and I explained this to her, I have a bifurcated billing system. Part of it's a retainer, that's a flat fee. The other part is an hourly when we get into motions and trial. And the fact that we're having such an issue with just the base retainer, I'm nervous. We go further in this case. We get into trial, we're going to have an hourly bill that's going to be accumulating, and I don't have confidence and that bill being paid timely. So hence the motion.
Ma'am, is he right? You laid out an agreement that you're going to pay?
We did have an agreement,
Ma'am, can I ask you why you just don't answer my question?
because
I think my questions are rather simple. Mr. Mullins has indicated you laid out a payment schedule to him. Is that right?
yes, but it wasn't the total amount being asked. The payment plan that was laid out was not the total amount that is requested. And so when I understand, when I say that there is confusion in reference to it, usually, for instance, people will sign a retainer fee with the lawyer, and that didn't happen. So once again, I did give him money to counsel me. But as far as the total amount, it wasn't.
Then ma'am, explain to me something.
Mhm,
If you haven't done that part,
mhm.
why shouldn't I grant his motion and just let him withdraw?
Because this is the probable cause hearing.
Because what?
This is the probable cause hearing.
Okay, and I give you another probable cause hearing. You won't be in any worse position.
Okay.
Because that's his obligation. His obligation is not to put you in a worse position when he goes to withdraw. And so that you understand what Mr. Mullins is really saying, and maybe he says just more fancy way than I would. He doesn't want to get to the point where either you're not paying him or something else happens in the case, and then he's either stuck because he can't have you in a safe spot, or he just has to try to get out to save himself, and you're going to be in a worse spot.
I understand.
So can you tell me a reason why I shouldn't let him out?
This is the judge offering the defendant control over her own narrative. He isn't hostile. He isn't dismissive. He's asking for logic, for cause, for law, and the response isn't legal. It's emotional. Confusion, fear, process anxiety. Courts don't operate on fear. They operate on harm prevention. And the judge makes it clear, withdrawal will not leave her defenseless. That's judicial ethics in action. No worse position, no prejudice, no abandonment. The system bends to protect continuity.
So I have a question. Can I ask a question?
Sure.
So let's say that you rule that he in his favor. So I would be given a.
Ma'am, let me stop. I'm going to tell you what I'm going to do, okay? And that way we can just put this to an end. I'm going to grant his motion to withdraw. I get it. I think you're a little bit worried that you're going to be left out there on your own. Here's PCC and whatever. Doesn't work that way here. So I'm going to grant Mr. Mullins' motion. Mr. Mullins is withdrawn from the case and further discharged of any obligation of this client or the court on this matter.
Thank you, Your Honor.
This now becomes a public defender case.
This is the safety net engaging. Public defenders aren't backups. They're frontline warriors, highly trained, deeply experienced, and often more trial-ready than private counsel. The judge reframes the moment. This is not loss. It is transition. And notice how he reinforces confidence. Very capable, extraordinary counsel. That language matters. It stabilizes the defendant. It restores equilibrium. The court's job isn't just adjudication, it's system continuity. No one leaves unrepresented. No case collapses due to payment failure. Justice doesn't pause because money runs out.
You're represented by the public defender of this juncture, okay? That way you still have counsel, very capable counsel to represent you in this matter. Ms. Anderson.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with and on behalf of Ms. Johnson Jackson. Your Honor, I asked for a couple weeks adjournment for us to get discovery and speak with her about the case.
All right. All right. Probable cause conference in this matter will be adjourned to July 25th, 2024 at 9 a.m. or as your invite indicates. Okay? Ms. Johnson Jackson, you understand?
Yes.
Okay, so you've got counsel now. They'll get the discovery. They'll be able to go through it with you and pace through it. It doesn't mean if you want to hire another attorney or somebody else, you can still do that. But you've got very, very capable, extraordinary counsel to represent you. So,
I understand.
okay. And so bond will continue.
Thank you, Your Honor.
Thank you.
What you've just witnessed is the machinery of accountability. Across these cases, a single truth emerges. Bond is not mercy. It's a contract. Every defendant here was given a chance to remain free. Every defendant was warned what that freedom required. And every consequence flowed from one principle. Compliance is currency. Tethers aren't symbolic. Exclusion zones aren't flexible. Drug tests aren't suggestions. Payment agreements aren't casual. The court doesn't operate on stories. It operates on patterns. Judge Simpson doesn't raise his voice often. He doesn't need to. His authority lives in structure, in process, in inevitability. Every ruling today reflects the same doctrine. If you follow the rules, the system bends to support you. If you break them, the system closes ranks to contain you. That's not cruelty, that's containment. And that's what makes these courtroom moments so powerful. Because every word, every pause, every decision shapes whether someone sleeps at home or behind a locked door. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.